Bisram.
Thank you, President Saunders. Caribbean Court of Justice, appellate jurisdiction on appeal from the Court of Appeal of Guyana. Judgment delivery in CCJ Appeal GYCR number 1 of 2021 between Marcus Bisram and the Director of Public Prosecutions. The court's full bench sits this afternoon. They are Mr. Justice Saunders, President and Presiding Judge.
Good afternoon, Counsel.
Mr. Justice Witt.
Good afternoon, Counsel.
Mr. Justice Anderson.
Good afternoon, Counsel.
Madam Justice Rajnatley.
Good afternoon, everyone.
Mr. Justice Barrow.
Good afternoon.
Mr. Justice Burgess.
Good afternoon, Counsel.
And Mr. Justice Jamadar.
Good afternoon, everyone.
May we have the appearances, please? Thank you.
Good afternoon, Your Honor. Mr. Darshan Ramdani, QC, leads me, Sanjeev Dattadin, Mr. Arudranath Gosai, and Mr. Dexter Todd for the appellants. And Mr. Bisram, who is, lean forward. He is also present with us.
Yes. And for the...
Please, Your Honor. Nigel Hawk appearing with Ms. Trishana Lake. For the respondent, we sincerely apologize and place on record the apologies of the Learned Director of Public Prosecution, Senior Counsel, who could not be here today, unavoidably. Obliged.
Yes. Okay, I would read a summary of the judgment. Marcus Bisram, a murder accused, was discharged by the magistrate for the evidence. DPP, by 2 separate letters, nevertheless directed the magistrate to reopen the PI and later to commit Bisram for trial, which the magistrate did. Contended that directives by the DPP, Section 72 of the Procedure Act, the Act, the existing law which empowers the DPP to so direct, is incompatible. Bisram claimed that the directions were unconstitutional because Section 72 is contrary to Articles 122A, which entrenches the principle of judicial independence, 4, right to the protection of the law, and to the separation of powers doctrine. He also claimed that in any event, the DPP had not precisely followed the steps that were required by Section 72. Justice Morris-Ramlall granted the orders claimed and ordered Bisram's release on the basis that no prima facie case had been made out at the PI, and that in any event, the DPP had not scrupulously adhered to the steps required by Section 72. The judge, however, declined to find that Section 72 was unconstitutional. The DPP appealed and Bisram cross-appealed. Court of Appeal allowed the DPP's appeal against the judge's orders and dismissed the cross-appeal that Section 72 infringes the Constitution. Court of Appeal held that Article 122A does not apply to the Magistrate's Court as it is not a superior court, and that as the DPP is not part of the executive, the directions did not contravene the doctrine of the separation of powers. Further, the Court of Appeal held that because Section 72 was an existing law, it could not be held unconstitutional, even if it was inconsistent with Article 144. Court of Appeal accepted that there was bungling by the DPP in the sending of the letters to the magistrate, but it found that this occasioned no prejudice to Mr. Bisram. The court thus held that the committal by the magistrate was valid. It is against those orders and findings that Bisram appealed to this court. This court first highlighted that a PI, though not a trial, is a judicial proceeding in which the accused is entitled to a variety of legal rights similar to those at a trial. However, a discharge at the PI is not an acquittal, and issues of orthorhorarchy as the accused was never placed in jeopardy. The court also noted that irrespective of the DPP's independence, what was pertinent was whether the Parliament could validly authorize that high official to instruct a judicial officer on how a case should be decided, how a matter should be decided. On the question of compliance with Section 72, the court noted that the section required the DPP to first receive the depositions and other material and to form an opinion from them that a prima facie case had been made out before directing the magistrate to reopen the PI and give the accused an opportunity to make a statement or call witnesses. In this case, the DPP made up her mind before receiving the depositions that the PI should be reopened with a view to committing the accused. In doing so, she failed to follow the carefully crafted procedural steps laid out in Section 72, steps which embody substantive principles of fundamental fairness and natural justice, conducive to the goal of a fair hearing. This failure rendered the subsequent acts of both the DPP and the magistrate susceptible to being declared a nullity. On the constitutionality of Section 72, and with respect to the separation of powers, the court noted that Article 122A speaks to official influence and control, which is broader than executive influence and control, and that the article itself makes reference to freedom from political, executive, and any other form of direction and control. The court also found that A, the placement of the article before Article 123, which establishes the Supreme Court of Judicature, comprising the Court of Appeal and the High Court. B, the reference in Article 122A to all courts, unlike the reference in Article 123 to those courts, meaning superior courts. And C, the nature of the magistrates' courts in relation to their function, scope of jurisdiction, and administrative autonomy, all point to the magistrates' courts being amenable to the provisions of Article 122A. The court held that a law that renders the magistrate's professional decision-making subject to the dictates of another official cuts straight through Article 122A and must be declared void to the extent of its inconsistency with that article. In this case, Article 152 of the Constitution, the savings provision, cannot apply as it only relates to inconsistency with fundamental rights falling between Articles 138 and 149, and Article 122A obviously falls outside that range. On the question whether Section 72, as an existing law, was saved and immunized from being held to be in contravention of Article 144, the court reaffirmed the modification first approach initially espoused in Nervez and embraced by this court in McEwan. The court held that the savings and modification clauses should be interpreted together so that existing laws should be first suitably modified before being applied. This approach allows courts to promote fundamental rights and freedoms by permitting them to identify an inconsistency between an existing law and the fundamental rights in the Constitution, and to modify the inconsistency out of existence. In considering the scope of the modification power outlined in Section 7(1) of the Constitution Act, the court accepted the opinion of the Labastide Chief Justice in Rudall versus the State, which was later specifically relied on by Lord Bingham in Mollison and cited by Lord Hoffman in Matthew versus the State. That opinion was to the effect that the Constitution has entrusted a sweeping responsibility to courts to appropriately construe existing laws that challenge fundamental rights. Finally, on the question of the consequences that follow the above decisions, courts separated these into two sets. First, those consequences that are in relation to Bisram, and secondly, those in relation to the future of Section 72. As to the first, the court agreed with Justice Morris-Ramlall that even if Section 72 were constitutional, the DPP's second directive to the magistrate must be declared a nullity. The court thus agreed with the trial judge that everything that followed the issuance of that directive must be quashed. The court also found that it would be unjust in all of the circumstances for Bisram to be made to answer any charge of murder in this case on the same evidence that was presented to the magistrate. However, because Bisram, at least in terms of the law, was never placed in jeopardy, nothing prevents the DPP from having him rearrested and charged again if fresh evidence was obtained linking him to the alleged murder. In relation to Section 72, the court noted that simply striking down Section 72 would leave a substantial gap in the criminal procedure without any certainty as to when that gap will be closed. Therefore, until the National Assembly addresses this matter, Section 72 should be modified to provide that a DPP who is for good reason dissatisfied with the decision of a magistrate to discharge an accused person may place before a judge of the Supreme Court the depositions and other materials that were before the magistrate on an ex parte application for the discharged accused to be arrested and committed if the judge is of the view that the material justified such a course of action. In all the circumstances, the court allowed the appeal and restored the decision to Mr. Bisram. Now, in our judgment, drafts of which you would already have seen, we have made no provision to costs because we hope that the parties will be able today to inform us as to some agreement that hopefully they would have made between them. So I would ask you to let the court know whether you were able to have a discussion on this issue. What is
May it please you, Darshan Ramdani here.
Yes.
We spoken with the Solicitor General, Mr. Nigel Hawk, but we were unable to get to an agreement. It's our position that we are making an application for costs to be awarded to the appellant in this case. If you would like to hear me now, here to go ahead.
Yes, before I give you the go ahead, is there anything that you wish to say, Mr. Hawk? Mr. Hawk?
Your Honor, that is indeed the position. We've had discussions, we are unable to agree. I've been all respectful, but we are unfortunately unable to arrive at a resolution. So
what was the resolution about? Principle of cost or about a dollar figure?
To be frank with the court, the suggestion on our side was that all parties should bear their own cost. That was the position we took. I think the side was a position that we're looking at the issue of basic cost. But I think the figures pose some problem in terms of my instruction for my superiors. So
okay.
Unfortunately, that is my
yeah. So the first position you had is that still that feedback. Somebody needs to mute. Is that each party should bear their own costs, and
yes, please, Your Honor. We took. Sorry, Your Honor.
The other side did not accept that. No,
the other side, I don't think they.
Your fallback position is that basic cost is, as far as you're concerned, exorbitant. Is that it? Am I hearing you right?
Yes, Your Honor. That is.
Did you suggest?
But I'm subject to the court.
But what?
No, I'm subject to the court's guidance here. So the issue is the figure.
did you suggest an alternative to the dollar figure set out in basic costs?
No, please, Your Honor. No, please, Your Honor.
Standard
No
cost, President.
Standard costs, yes. And was that because you didn't have enough time?
I think we ran out of time to some extent because I am required to go, even I don't have the power to make certain decisions. I'm required to seek approval from my superiors. So I was in active discussion with learned Queen's Counsel, Mr. Ramdani, on the issue, even just before the court took to the bench.
Mr. Ramdani,
We ran out of time, so to speak.
Mr. Ramdani,
Yes, please, Your Honor.
would more time, do you think more time would that there is the possibility of an agreement if you had more time?
Your Honor, it seems to us that we have presented our position. We are hoping also to be flexible, and we've indicated that. There is nothing coming back from the other side in terms of whether we would look at standard costs, whether we would go under what I believe now to be the old regime of basic costs, or whether some other figure is being suggested. So we continue to remain flexible, Your Honor, but we continue to hope that we will have something tangible from the other side in relation to this issue. I didn't quite hear all that Mr. Hawk said, but is he saying that they need some time, Your Honor? Because we are prepared to speak to them.
Okay, I tell you what, it was 5 or 10 minutes, and we'll come back to you.
Obliged.
Thank you, Your Honor.
Okay, counsel, this is what we would do. We would give you 3 days. Today is Tuesday, Wednesday, Thursday, Friday. We'd give you until close of business on Friday to get back to us with an agreement on costs. If you do not do that, if you are unable to agree, then we give you until next week, Friday, to make submissions in writing, no greater than 5 pages in length on the issue of costs. And on the basis of those written submissions, the court will give its decision on costs. In the meantime, the order that will be appended to this judgment is that the court reserves its position on costs until it has heard from the parties.
Thank you very much, Your Honor. May I respectfully ask, Your Honor, in relation to the orders that have been made, the consequential orders, Mr. Bisram's passport is still lodged. I know that it is considered that that order expired, but may we kindly ask that an affirmative order be made for the release of that passport back to Mr. Bisram, please?
Yes, in fact, yes, orders. Could everybody mute, please, because we're still hearing the feedback. One of the orders that is made is that the order of this court that was made on 11th of June is spent and no longer in effect. If that did not cover it, we are prepared, and we do make a further order that Mr. Bisram's passport be returned to him forthwith, unless there are any other charges on the basis of which that passport is being kept. But certainly in relation to the charge of murder, which this case is concerned about, if that passport is being kept on the basis of that charge only, then it must be returned to him.
Thank you very much, Your Honor.
Just the orders which you would have seen in the draft which was sent to you to encompass both this last one about the return of the passport and also the order for costs being reserved. But subject to that, which you would receive in due course, the draft that you have seen is otherwise effectual.
President,
Thank you very much.
I think the order that you suggested now, additional, would seem flows automatically from the order that we already have in the judgment. So,
So
could
it's
the DPP simply acknowledge that that passport is going to be given back so that we don't have to say what is obvious?
Yes. Mr. Hawke, I know you dropped off a little bit because I saw you just came back.
Sorry, my internet went a little bit.
Right.
Sorry.
But can I get an undertaking? Can the court get an undertaking? Well, first of all, is there any other basis upon which Mr. Bisram's passport is being retained?
I don't think so. I will certainly intimate to the honorable the DPP, the court's position. I think that will be the legal position for it to be returned.
Yes. So
the matters are now finished.
You would let the DPP know that the court has ordered that document, that the passport be returned to Bisram.
President, a question arises: who is retaining that passport? Is it the magistrate?
I understand it is the Registrar of the Supreme Court, Your Honor. And there's another issue that arises, if I may. It is believed that his name is also placed on a list at the ports of exit. And we would ask that that be clarified, that his name is also removed. Many lists that prevents him from traveling.
That is not something that does not flow naturally from what is here. That's a matter which the executive is involved in, and you would have to bring separate proceedings on that if you have a difficulty with it. But that does not flow inexorably from the orders that we have made.
Your Honor, just a clarity. I know the court intimated to us that the court was giving us until the close of business on Friday, but I dropped off just at that point.
Ah, I see.
Sorry.
Okay. We would hope that both sides could agree costs by the close of business on Friday, and that you will, by that time, inform the court what that agreement is, so that we can put our imprimatur on that agreement. If you are unable to agree by Friday, then you have until close of business on the following Friday to make submissions, and we're not going to order sequential making of those submissions. Each side would get in their submissions, if we get to that stage, which I hope we don't, by Friday on the issue of costs, 5 pages, and then we would give a decision on the basis of those written submissions.
Guided, Your Honor. Most grateful.
Yes. Is there anything else?
Nothing from our end, Your Honor. Thank you very much.
Okay. Well, thank you very much, Counsel. And Ms. Thomas-Roberts, you can close the proceedings.
Thank you, President. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Madam Justice Rajnath-Lee. Thank you, Mr. Justice Barrow. Thank you, Mr. Justice Burgess, and thank you, Mr. Justice Jamada. Thank you, Counsel, and thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.
Right, good day.
Right, good day. So, no.